Hello, everybody. Thank you for joining us for Tuesday Talks. This is Nicole Weston with the ACI Alliance, and I'm going to hand this event over to our capable moderators and our panelists. Take it away, Miranda and Rosie.
Thank you. Good afternoon, everyone. Welcome to our ACI Alliance Tuesday Talk. This webinar is being recorded. We are your moderators. I'm Rosie Finnegan, and I'm joined today by Miranda Myers. I am the parent of a 13-year-old daughter who is deaf and has been using bilateral cochlear implants for about 10 years now. She's in 8th grade, and she was the voice of Cece and El Deafo for the Apple TV series based on the book El Deafo by Cece Bell. So be sure to check that out if you haven't already. It was released early this year. Like many of the parents on the call today, I've had to navigate the IEP process, which can be extremely challenging. So I'm really happy to be a part of this call today. I'll let Miranda introduce herself.
Hi, I'm Miranda Myers. I am 25 years old and I'm a bilateral cochlear implant user. I got my first implant at 2 and then my second implant at 18 years old. And I'm 3 years out of college now, and I work in politics and government affairs and public affairs in DC and in my home state, New Jersey.
So this talk is part of an ongoing series for parents, as well as adults with hearing loss, family members, and others. As members of ACI Alliance Advocacy Network, CI CAN for Cochlear or Cochlear Implant Consumer Advocacy Network, we hope you learn from this session and consider getting involved with the wonderful work of ACI Alliance.
Next slide, please. So first, let's review the technology and go over the Zoom settings that will help you. To access the closed captioning, please click on the live transcript box on your screen as shown in the slide. It's usually at the bottom, and then click Enable Live Captioning. If there are any concerns, please, please send a message to the host via the chat box. And then to ask a question, please use the Q&A box.
Next slide. American Cochlear Implant Alliance is a unique organization focused on CI across the care continuum. We were founded because it was felt that cochlear implants fall through the cracks at other hearing organizations, and we wanted to focus attention on improving access to CIs. The mission of the ACI Alliance is to support research, advance awareness, and advocacy.
Next slide, please. CI CAN stands for CI Consumer Advocacy Network, and it's for adult consumers and family members of recipients, including parents, and it's aimed at enhancing and enlarging the broader advocacy efforts with firsthand knowledge of cochlear implants. Personal stories really make the difference in impacting decision makers, and it adds credibility in our contacts with state and federal representatives on key issues. If you're interested in learning more, please let us know in the chat box, and ACI Alliance staff will follow up with you later.
Next slide. We also wanted to share a few of the ACI Alliance website resources that are available. I actually shared our personal story for the Parent Perspectives column, which you can find in last month's edition of Calling, which is a quarterly e-magazine published by ACI Alliance. So I hope you'll check that out.
Next slide, please. And now we are delighted to introduce our featured speaker today. John M. Flanders is an attorney in private practice. For the last 22 years, he has represented the needs of families that include children with disabilities to ensure that they receive the appropriate education they need and deserve. He is a graduate of Brown University and the University of Connecticut School of Law. In addition to his legal practice, John has served as the children's rights advocate for the H.E. Bell Association for the Deaf and Hard of Hearing. As the First Selectman of the Town of Cromwell and the Executive Director of the Connecticut Parent Advocacy Center, he is the Vice President and a founding member of Special Education Equity for Kids of Connecticut, where he actively advocates for systematic change to protect the rights of students with disabilities and their families. He is a member of the Board of Directors for the Connecticut Association of School-Based Health Centers and serves as the chair of the Legislative Committee. He's married to Dr. Ann Camp, and they have one son, Dr. Nathan Flanders, who has a profound hearing loss. Take it away, John.
Hi, and thanks for having me. Because I'm a lawyer, I always have to start out anything I say with a couple of small caveats. First of all, we're going to talk about the Individuals with Disabilities Education Act, or IDEA. IDEA is a federal law. It's covered nationally, and it sets the floor for the states around the country. So it is entirely possible that there are things in your state law that I'm not going to talk about because I don't know about them. And before you do anything with any of this stuff, I strongly recommend that you see what the laws are in your state. The other thing is that while I am a lawyer, I'm not your lawyer. So nothing in this program should be considered legal advice. Always check with someone who's knowledgeable about where you are before you take any actions. So I'm going to give a very basic talk about how IDEA works with kids with hearing loss, and in particular kids with cochlear implants. Hearing loss represents a fairly small minority of the children who are covered under IDEA, and it is almost unique in that most of the conditions that are covered under IDEA involve children who face challenges in processing the information that they receive. For children with hearing loss, much of the issue comes from getting that information from the educators into the heads of the kids. So both the rarity and this difference make it challenging for many educators to effectively understand what's going on with your child, and it results in problems. I hear quite a number of parents who've come to me and said, well, your kid has a cochlear implant, he's cured, why are we worrying about this stuff? And that's not quite true. So we're going to look at that, and we're going to look at techniques that you can use to move through this process. So next slide, please. One of the big challenges that many people have when they look at IDEA and look at special education is that they don't realize that the law performs something of a hopscotch. And you have to step on every square in order to get from starting the process to getting an appropriate educational program. Just to start, the law defines a child with a disability as someone who is eligible for services under IDEA. That requires a two-step process. One, does the student have one of the 14 identified disabilities? Or if you happen to live in Connecticut, 15 identified disabilities. Then, once we've determined that he or she has this condition, does she then require special education to address the needs caused by that disability? Then the third step is we design an individualized education program to meet her unique needs and her unique strengths to get an appropriate education in the least restrictive environment possible. I will try very hard not to use education jargon or teacher speak in this, but if you catch me doing that, please pass a question on, and my colleagues will interrupt me so that I won't be that unintelligible. Can I get the next slide? So the very basics is a child with a disability means a child evaluated in accordance with several arcane steps as having a number of disabilities, including hearing impairment, which subsets including deafness. There's also there's also a section for students who are deafblind. And it is possible for a student to have more than one condition. There is nothing about hearing loss that prevents someone from having, for example, attention deficit disorder or an emotional disability, as we changed the law in Connecticut just recently. So when the school is doing these evaluations, yes, it's obvious a child who has a cochlear implant has a hearing loss, and that's part of the evaluation. But the team, the IEP team, is required to evaluate the child in any specific challenge of their disability. Essentially, that first step is to find a box to check off on the square, on the form. Yes, this child has a disability. Then we start looking at the child to determine what exactly is facing her when she's in class, and what needs to be done. The second step, it says who by reason of these disabilities needs special education and related services. If I get the next slide. And this is one of the challenges where things come up for kids with hearing loss. Special education means specially designed instruction. And what specially designed instruction means changing the way that material is taught, or the material, to address the unique needs of that student. So a child with a hearing loss with typical intelligence may not need to have the material she or he is learning in class adjusted. And because so many programs work on a failure model, the fact that you can do grade level work interferes with their ability to see the need for special education for the child. What is different is the means of presentation of that material. And kids with hearing loss, kids with cochlear implants, quite often need to have that, that part of their education adjusted in ways that are appropriate. The other question, next slide, please, is that many of the services that kids need, whether they need speech and language, for example, or occupational therapy, or what have you, fit under the definition of related services. IDEA separates special education from related services. Related services are the not classroom related or not classroom activities. Like I said, going off to a separate room for speech and language, for example, is quite often considered a related service. And IDEA says that a student who only needs related services and not modified education may not qualify under IDEA. So that turns out to be one of the brick walls that families in this venue run into, simply because, yes, your child needs to have various accommodations, and yes, she needs to have speech and language, and yes, she needs to have whatever support, but those are all related services, and therefore she doesn't qualify for special education. In most cases, that assessment is wrong and is based on inadequate information, and it falls upon you and I as parents to educate the members of your team in the need for defining the student as a student who qualifies for special education under the law. Next slide. Just a list of special education or related services. Audiology obviously is one of them. Speech and language varies by state. Some states define speech and language therapy as special education. In a large part, in my state, in Connecticut, they do consider that to be special education. But other things like interpreting are not, even though it modifies the way that the material is presented, many states consider that to be a related service, and it turns out to be a challenge in some cases. Next slide. One particular exception in the law from the most recent iteration for kids with cochlear implants is that Congress, in its wisdom, explicitly excluded mapping from special education services. That the thought process, well, I'm not going to editorialize on the thought process on that, but you need to be aware that as a rule, no school is going to support your child in getting their cochlear implants mapped, even though proper mapping makes education far more accessible to the student. It is not a hill that you want to die on fighting, because basically you're going to lose at this point. It's very black letter law. Next slide. This exception doesn't affect anything like using assistive technology like an FM system or a sound field system or Roger Penn. It does not include any of the other aspects of assisted technology. One of the provisions that often gets left out in an IEP is that when IDEA talks about assistive technology, they also talk about assistive technology training. And that means teaching your child how to use this technology, teaching the educators who work with your child how to use this technology, and teaching you as parents how to work this technology and how it impacts on your child's education. So as you're crafting the IEP, that's an important question to ask about. What are we going to do to train everybody that's on this team that's working with John or Sally to make sure that their technology is working properly and that they're using it properly? A very common story, and Nate used to tell it, his teacher would often leave their FM transmitter on when stepping away from the classroom, and he found himself at the end of 12 years of school knowing a great deal more about the bathroom habits of the educators that he worked with than probably was wise. He also used to cheat because the coaches, when he was doing sports, would often have the FM, and he would listen in on talks for the other team. Anyhow, next slide. If your child fails to qualify for special education, if you come to a point where the assessments and evaluations that you've done determine that he or she does not require special education, it is not the end of the world. There are other federal and state laws that cover people with disabilities that have different qualifications. The primary one, and the one that you will hear in school mostly, is Section 504 of the Rehabilitation Act. All of the language in Section 504 is also repeated in the Americans with Disabilities Act, but most schools, at least in our area, refer to Section 504. 504 requires that a student have a condition that significantly impacts an activity of daily living. Anybody who has a cochlear implant or any hearing loss at all has a condition that severely impact or significantly impacts their ability to hear, amongst other things. Any child with a cochlear implant is going to qualify for services or accommodations under Section 504. Under that law, a student does not get special education, but they do get reasonable accommodations. And reasonable accommodations are changes made in their activities, their presentations, that make it possible for them to have equal access to that. So that can include preferential seating, that can include assistive technology, it can include sound field systems, it can include affecting the acoustics of the classroom, anything sort of that makes it mechanically easier to get access. In many cases, that's enough. So as you're going through this process, you, with the experts that you work with, need to consider whether you can get enough. And if you can, then maybe getting in a fight is not what you want to do. Maybe what you want to do is to help design and craft an appropriate 504 plan that can meet all of his or her needs. But that's a question, and that's a question that needs to be asked, and it's a question that needs to be addressed with data, with information, not speculation. Next slide. This is simply talking about the differences between special education and accommodations. Amongst the things that are probably most important, especially for, well, I won't say especially for young children, because it has a lot of impact for students in secondary schools, is one of the things that many children require is either pre-teaching or post-teaching of the materials in the classroom. Using hearing technology can be very, very tiring. And even with the best stuff, things get missed. So that having the opportunity to work with an educator before, after, to fill in the blanks that were missed during the classroom session is often a vital link for the student in order to be able to keep up. Things like sending extra material home, making sure that you don't, that examinations and things are done properly. I can't tell you the number of times that I've sat in meetings where Donna Sorkin, who's on our panel hidden, has done the unfair spelling test and walked around and had people put stuff in their ear and ask them to spell word. Those probably, in my mind, qualify as special education. On the other hand, if the teacher is going to do all that stuff and they want to call it a Section 504 plan, that may not be where you want to fight. Teaching teachers how to present, no writing on the blackboard and facing away from the students and things like that, all can qualify as special education. But again, it is, from your perspective, look at what's going to be done and see how, if you feel, and if the experts who work with you feel, that's going to be adequate to meet his or her needs. Next slide. So what do you need in this process? You need data. You need more data, and you even need more data than that. I don't think in 22 years of doing this, I have ever run into a situation where there's a conflict between parents and the schools about their child's program where either side had enough information to drive what really needs to be done. I spend a huge amount of my time early on in a representation getting the schools to evaluate children to make sure that we have enough information about their needs, and that includes all their needs, in order to make appropriate decisions about their program. You can't have too many evaluations. And the people who are in the school, because hearing loss is relatively rare, are probably not going to know all the evaluations. Doing an audiogram, for example, will give you a lot of great information about how well the student is hearing, but it doesn't give you very much information about how effectively sound and information is getting to her in a classroom or in a gym or in any other situation where she's going to be. You need you need a functional listening assessment in order to determine things like that. So leaving it to an evaluation that says, well, we were in a sound booth and she worked real well in that speech banana is great, congratulations, but it doesn't tell you much at all about how she's going to do in the third row next to the air conditioner in the classroom in 6th grade. You need to get a lot of information from anybody that you can talk to, from the teachers. Lean on the teachers. How is she doing? What is she missing? I can't tell you the number of kids where we talk to the teacher and the teacher says, it's just so frustrating. She's not listening. Well, yes, she is listening. She can't hear you. And maybe that's a need for adjusting. Support staff. Sometimes kids have paraprofessionals or the speech and language pathologist or anybody that he or she is working with should be opining professionally and probably with tests and certainly with documented data about how she's doing and what her needs are or what her expectations are. For cochlear implants, you are going to have medical professionals involved. Medical professionals are wonderful people. I love them to death. They almost always do this wrong. Medical professionals are used to giving advice that must be taken. I have many cases where a parent has shown up at school with a prescription pad that says, John needs special education, signed doctor, because he has ADHD or because he has, and handed that in. And unlike your pharmacist, your educators don't have to read that prescription as Holy Writ. They have that second step in the process first, and it is a medical evaluation and not an educational assessment. So when you are dealing with these folks, and I spend a fair amount of time talking to doctors and a fair amount of time teaching pediatricians and others, that it has to reflect the fact that this is not a medical condition that we're talking about, but the educational impact of the situation that they're talking about. So your job as a parent is to be talking to all these people and helping explain to them the problem that they're facing. Not the problem that they're used to working with, but the next step on the process to get him or her an appropriate educational program in place. If you learn nothing else from this, you learn that there needs to be at least 3 professional evaluations before any IEP team meets. And that would be an absolute minimum. There's stuff going on that kids know. Everybody thinks, well, you have a kid with typical intelligence and performing well. Why do we need to, and a technology that helps her hear, and why do we need to check her educational performance? Because these things change and she didn't hear a lot of stuff. So educational assessments can be very, very important, even though it looks like something that doesn't fit within the boundaries of hearing loss. Next time. To get evaluations, IEP teams choose what evaluations are done and they order them. So in your team meeting, you need to be making suggestions about what evaluations need to be done. You cannot assume that they know what to do. They've seen 3 kids with hearing loss over the past 10 years. One of them has hearing aids, one of them is using American Sign Language, and your kid. And their needs are all different and unique. And the stuff that they evaluate for needs to reflect their unique needs. One of the situations that you run into is a school that 4 years ago had a kid who was capital D deaf, who used sign language. And that kid did well in school with his interpreter and got into college. We know how to teach care. We now are sure that we know how to teach deaf kids. And we're going to use the plan that worked so well for him 4 years ago on your kid, even though everything is different. So ask. And before you ask the professionals who deal with your child what you should ask, because it's always better to have a statement, to walk in and say, Joe Smith with 6 or 7 initials after his name recommends that we test this, than to say, I'm mom and I think this needs to be done. Initials after your name are always good. When they do the evaluation and when they do special education, one of the rights you as a parent have is what's called prior written notice. Prior written notice says that anytime a school proposes to do something, including an evaluation, or refuses to do something, including an evaluation, they have to provide you with written notice as to why. And that written notice needs to refer back to the tests, the information that's on the table when that decision was made. I've seen a whole heck of a lot of IEPs where the prior written notice said, we're not going to do this evaluation because the team agreed to it. That is not an appropriate prior written notice. Why did the team not agree to it? And you have rights, and there's no way I can fit it in here. But when you talk to support people and experts, talk about your rights to make sure that that reflects what actually happens and what the real factors in the decision-making process are. Another right that you have as a parent is what's called an independent educational evaluation. There's 2 types. One, anytime you want to take out your credit card and get somebody to evaluate your child, you have the perfect right to do so. You have the perfect right to bring that into your child's IEP team, and they must consider it. You also have the perfect right to withhold that information from the child's IEP team if it doesn't say what you want it to say. What most people talk about when they talk about IEEs, and you will hear the term IEE a lot, at least in my world, is you have the right, if an evaluation is done with which you disagree, with which you feel is incomplete, or with which you feel is violating your child's privacy, to ask for an evaluation by someone not employed by the school. You also have that right if the school refuses to do an evaluation that you request. That triggers a two-part test. One, the school then must give you the information on the qualifications of the people that did their evaluation, or the qualifications of the people who would do your evaluation, and any other limitations. Unfortunately, you're not going to be able to fly yourself over to Vienna to get evaluations from the world's greatest expert on whatever, for $100,000 when a school psychologist can do it for $1,000. But so there are limits, but they are pretty flexible in most places. If they don't agree to allow you to do that evaluation, they must immediately, without delay, file for a due process hearing against you. And they must go before a hearing officer and prove that their evaluations were appropriate, or their decision to not do an evaluation is appropriate. If that happens to you, call a lawyer. I'm not doing that to promote income or anything. A due process hearing amounts to a trial. You don't know the rules, and it is something that you really, really need to have professional help done. Most places don't do that, at least in my world. I don't know how it is in other states, but most places in Connecticut don't want to spend the money on their lawyers to fight it, and they will spend the money on the evaluation to go forward. Next slide. Another right that you have is you have the right to bring pretty much anybody that you want into an IEP team meeting with you. That can be somebody like me, it can be a lawyer, it can be an advocate, it can be your mother-in-law, it can be your next door neighbor. And I quite often recommend that people bring a friend or a relative or whomever into it, just as somebody to listen and take notes. These meetings can be fast and they can be emotional for parents, and you miss stuff. And having somebody there taking notes and remembering what's going on is very, very useful. You also have the right to require experts to come in. And so if you've done an evaluation and you want to get the audiologist who's been doing the work to come in, there's nothing that the school can do to prevent you from doing that. And I encourage you to do that. And if you've gotten an independent evaluation at the school's expense, I always recommend to my clients that they have that evaluator come in, because they have particular expertise on how the evaluations are done and what information has been collected. Next slide. Sorry if I'm talking fast. It's an occupational hazard. Places to get help. IDEA requires that every state have at least one parent training and information center. They are universally excellent resources for parents in understanding the rules and laws. You can look them up. I think in the next slide I have address where you can look up the ones in your state, and I highly recommend calling those folks up and getting help if you have any questions. There are also a lot of state or national groups. In my biography, it mentioned that I'm part of SEEK, which is Special Education Equity for Kids. We are a state group, and we provide help for parents and information for parents. So look around to see what's out there. And certainly groups like ACI have a lot of information to provide for you. A last group that I will recommend, and I'm a member, so full disclosure here, is COPA, which is the Council of Parent Attorneys and Advocates, which is a national organization of lawyers and advocates who represent families. I think it costs $50 for parents to join the organization, and there is a tremendous amount of resource and a tremendous way to access the professionals that can represent or advise you in this from COPA. Next slide. A couple of more resources, and I'll give a special plug to Your Special Education Rights, which are written by two very good friends of mine. It's a fine book, and it outlines in actual English a lot of what's going on in this. The IEP guide by Larry Siegel is also a very good English language description of it. Other organizations, Parent Center Hub is where you can find the PTI for your state, and also a lot of information. COPA has their own website, and I didn't put it in there, but it's copa.org. And if you happen to be in Connecticut, feel free to reach out to us at SEEK, and we'll be happy to share what information we have with you. Next slide. Or am I done? I talked a lot and I talked fast. I hope there's some questions that I can respond to. We gave this a pretty 20,000-foot description of the law. So lay them on me.
Yes, thank you, John, for that wonderful presentation. We already do have some questions, as you can imagine, in the Q&A. So anyone else who wants to submit a question, you can please do so in the Q&A. So I'll go ahead and start so that we have time for these. So the first question says that preschoolers in our state often do not qualify for an IEP. Parents are told that 504 plans are not required until kindergarten. The school just says that they have no responsibility to make sure the child has access to instruction in their church preschool or all-day childcare. Can you speak to this?
That is absolutely baloney. Let's start with the first level. Section 504 requires equal access to programs, any program that receives federal money of any kind. So there is preschools are going to have federal money. They are subject to Section 504, and they must provide educational support. Second, IDEA actually has two parts. Part C provides services for children from birth to age 3, so that it is a warm and fuzzy place where a family gets an individualized family support plan, where quite often people come to your house and provide services, and it's all very nice. But then it requires a transition at age 3 from Part C to Part B, which covers children and young adults from age 3 to 21 years old, or in the case of Connecticut, your 22nd birthday. The law explicitly requires that a child at 3 years old, a preschool age child, be at least evaluated to determine whether or not he or she requires special education. Maybe if there's not a lot of teaching going on in the preschool, that can be dealt with accommodations. That's going to depend on the individual child. But to say that you don't do a preschool child is absolutely baloney and a complete and total violation of the explicit letter of the law under IDEA. So I'm guessing if this is common knowledge in your state, that a lot of folks at your PTI have heard this, and I would give them a call and see what they've done on it, because that's just absolutely flat out, no holds barred, no ifs, ands, buts, gray area, wrong. How's that? That's very unlawyer-like to say something that definitive without a but. Might get disbarred.
So the summary answer to that question is they have to provide services.
They don't necessarily have to provide services. The thrust of that is that they have to determine whether or not they have to provide services to provide that child with an appropriate education. So she may not need services, but they can't just say, no, we're not talking to 4-year-olds. It's just, that isn't the rule. Is that a little, did I get rid of my fuzziness there?
Yeah. Yes. Thank you, John. We have another question for you. What if you have the evaluations that show deficits, but they're not considered? How do you advocate for the differences between the school assessment and the private assessment from our own speech, occupational therapists, physical therapists, and psychologists and audiologists?
Yeah, that can be challenging. The law says considered, and it doesn't define what considered is. We read it and we don't think they're right is probably not consideration. So you have to go back to the prior written notice that I talked about. So if they have an audiology report, for example, that says that this child is operating in the speech banana and doesn't qualify because she doesn't have a disability, which I've seen, and you have a report from an audiologist who's been more comprehensive and says, yes, we get these results in a listening booth, but we get this result in public and this result in the classroom, which are entirely different. When the school says no, they have to give you written explanation of why. And that needs to be in the prior written notice. If it's not there, then you have ways under IDEA and under what's called FERPA, which is the Family Educational Records and Privacy Act of putting your opinion on the record, putting your statement on the record, and saying that, no, clearly you didn't consider this. One of the problems under IDEA is that it doesn't include a lot of cops. The responsibility for enforcing the provisions, if a school doesn't want to do it, unfortunately falls on you as the mom and dad. And you should talk to people who deal with this kind of dispute. Again, the PTI is probably a good place to start, but talk to somebody like me or an advocate about that, about what you can do to incentivize the educators to do the right thing. Ultimately, your big stick is to file for a due process hearing against the school. That is a big deal. I happen to live in the state that does it the most of all 50 by a factor of 3 or 4 from the next state. We file a lot of due process hearings. When they go all the way through the process, they are expensive and time consuming and absolutely no fun. You know, it can run you $6,000 to $10,000 for a lawyer for that, but you still have the right to threaten it, and you still have the right to start the process and do everything. But before you do that, talk to somebody who knows about this, and talk about having somebody in the room, either a lawyer or an advocate in the room with you. I can't tell you the number of times, and it's not because I'm particularly wonderful, but I'll go into an IEP meeting with a family who has been getting no, like that. And having somebody in the room who actually knows what the rules are changes the conversation almost automatically. So consulting, at least consulting with somebody is often a good idea. The other thing is to educate yourself to the degree that you possibly can on the rules. And if you can walk in there and quote chapter and verse and say, because of this provision of IDEA, and give them the numbers and the letters, you're required to provide me with prior written notice of the consideration that you gave to my evaluator. That often makes people take a deep breath and step back from the edge of the rules. So educate yourself and find yourself some allies is the big answer on that.
Okay, our next question. Do parents have to notify the district that they are pursuing an IEE? I've heard of some districts that won't accept the findings of the IEE if they weren't notified in advance and agreed that the person conducting this new IEE was qualified.
No, they don't. Now, if the person that you had doing the evaluation isn't qualified, then that makes their evaluation less credible. But one of the things about an IEE at your expense and on your dime is that you don't have to share the results with the team. So if you're not sure, if you're trying to get more information to clarify things in your own head, and you may not want to share the information, then telling you that you have to notify the school ahead of time takes that right away from you. So absolutely not. It's explicit in the IDEA that the team must consider any data, in fact, any concerns that you have, even if they're not documented by a professional. All of those must be considered. So to say no, because you didn't tell us you were going to see Dr. So-and-so, we're not going to look at his results, is wrong. It's a violation of the law.
Okay, next question. With the IEE, if you cannot get the psychologist they recommended to contact us back, can you go outside to another person? Also, what if who they recommend does not know what an IEE is? What do you do?
So they can recommend people, they can give you a list of people that they recommend, but the law says that you get to pick as long as they meet the appropriate qualifications. So if they say we're going to use whatever child psychology practice in the next town, there's nothing that requires you to go to that group. If you want to, you can pick somebody from wherever, as long as they meet the requirements, and the requirements have to be reasonable. I live in a small state, and for a while Connecticut tried to say that you could only have people who worked in Connecticut. Fairfield County, that little thing that sticks out the bottom of Connecticut into New York, very few of those people actually realize that they live in Connecticut. They do everything in New York, and to have them have to drive an hour and a half to Hartford to get an evaluation when they can drive 12 minutes to New Rochelle to get somebody equally qualified is finally persuaded our State Department of Education that maybe that in-state rule was inappropriate. So now you're probably not going to get to, if you're in Pennsylvania, nobody's going to fly you out to California to do this evaluation. But just because they pick Dr. X doesn't mean that you have to use Dr. X. And in fact, it's explicitly not somebody that's on the list. I will tell you, here in this state, it's not in the letter of the law, but quite often the school and the parents will negotiate over somebody that they can both live with, which is not at all uncommon, because there are plenty of people who, if you've got somebody that does 40 evaluations a year for their for your school district, they have an incentive to lean their evaluation towards what the school district wants. That's a chunk of their income. And while nobody is going to behave unethically, people are human, and those become factors. So the list that the school provides you is not all encompassing.
Hey,
Apparently we ought to do a session on individual education as evaluations and
yes, a lot of questions about this topic for sure. And they're great questions. Our next one asks, do any of these rights change when requesting an evaluation for gifted services? Could an IE be requested if the school psychologist is unsure how to evaluate a deaf child? And if I can speak for a moment, John, we had this experience ourselves, and you are certainly allowed to ask the school psychologist how, if she has evaluated kids who are deaf. I know ours said she only evaluated a couple. My concern was at a young age, a lot of the materials presented verbally, so the auditory memory is quite different. I know that was a challenge for our daughter. I ended up going, and it was close to summer, and getting our own independent psychological eval, and then our team did take ours because our evaluator had much more experience and did kind of present the material in a different way. And a child can be on special ed and gifted services, at the same time.
Yeah, gifted services are coverage for students with exceptional abilities is also covered under IDEA, at least in my state, and I can't speak for anybody else. Receives a moderate amount of lip service. Mostly it receives a wave we've got, we've got kids who are in diapers. We're not going to go way out of our way for your kid who's too smart for 6th grade. So working my way through that back to the question, what we often do is when a school is trying to do an assessment and evaluation, because they're supposed to be doing all of the students' needs, is we will say something to the effect of, well, that's great. You as the school always get the first bite of the apple of determining who does the evaluations. That's their job, and they get to pick. But you can say something to the effect of, we know you get the first bite of the apple, but you need to know that if I find a single T that doesn't have a perfectly horizontal cross on the evaluation, that I'm going to be asking for an IEE. So why don't we talk about finding somebody that we can both live with? And that happens in my life all the time. I don't actually say those words, but we're going to look at this very carefully, and if we see anything missing, we're going to make you do it again, and you're going to pay twice as much. So let's try and get it done right the first time.
And speaking of that, their next question is, when requesting a reevaluation for my child, what is the most important thing I should know?
So the law requires that your child be reevaluated at least every 3 years. You'll hear the word, at least in my world, you hear the word triennial a whole heck of a lot. What folks don't necessarily understand about that is that is the floor, not the ceiling, and that the team is required to reevaluate a child anytime that they see that the information that they're working on isn't adequate. So if your child is struggling, then probably his IEP is not appropriate for his needs, and we need to revise that. And in order to revise that, we need to have more evaluations. So I think probably the single most important thing that you need to know is that you can ask for an evaluation anytime you want to. You could ask for new evaluations every day. Don't. That will cause more trouble than it's worth. But that you absolutely have the right to say, look, he's struggling. We need to relook at whatever. Pretty much any time that you want, and once you've made that request as a parent, that triggers all the rights that go further on down the road.
Our next question asks, what consequences do schools really face for not following the IDEA or an IEP?
Bad karma.
Angry parents.
Angry parents. There are no penalties under IDEA. If an IEP isn't being followed, the parent has the right to exercise all of their rights. They can file for a due process hearing. They can file a complaint with their State Department of Education, who then is supposed to investigate and determine whether or not they are failing to provide the appropriate education. So those are your venues. Unfortunately, there's no special ed cop. You get that badge as a parent when you go into this process. So you're the one that has to take the steps that go forward. And I guess I should elaborate a little I talked about due process as being the ultimate. There are steps in between. One of them is a state educational department complaint, and that tends to be a better first step or a better third step before due process, that you reach out, and there needs to be a mechanism, and you should be able to find it someplace on your State Department of Education's website for steps to file a complaint. You then file it, they're required to investigate it, and then they come up with a ruling within 60 days to determine, for example, that the school is not following the IEP. And they can issue orders to make them do their job. That's about it. Unfortunately, there's no punitive damages or corporal punishment or anything like that available when folks don't do what they're supposed to be doing.
Okay, cool. We have time for, I think, just one more question. I think we're already going over. So this will be our last question for the day. So this woman is a director of special education at a school for children with hearing loss. And she says, we typically are told that our children transitioning from EI services to school-based services do not qualify for special education due to having speech and language scores within normal limits. We struggle with helping a district recognize that a child at 3 who may score within normal limits on assessments may actually have a long way to go to develop complex language, and that they would require continued direct instruction to teach complex spoken language. Any insight on how to help a district understand this?
You need to be able to document your opinion on that with some sort of an assessment vehicle. I mean, IDEA does not allow a school to deny services based on a single assessment vehicle. So if you do a standardized speech test and the child is able to identify letters and colors and things like that, and fits within the typical range, that's one evaluation. But you need to find a way, you need to find either another evaluation or provider observation or whatever that shows that this child has deficits that need to be addressed in order for her to continue to develop appropriate language. One of the things that I run into a lot is a kid is getting services and we say, well, great, having these services has brought him up to an age appropriate level so we can stop. It's sort of like saying, well, I managed to get to work today, and so I'm not going to bother putting gas in my car anymore because I found an appropriate way to get to work. If they're at a level because of the services that they're getting, chances are pretty good you need more documentation to say stop doing that. So if a child in birth to 3 is getting speech and language services and has reached an appropriate language level, that doesn't mean that he or she doesn't need those services. She is where she is because of the services. And to say, well, let's stop and wait until she fails in 2 years and then start this over again is remarkably counterintuitive and silly. I blame Amy Rowley for this. I don't really. But one of the seminal cases, which you will hear hundreds and thousands of times as a parent, is Hendrick Hudson's School District versus Rowley. And that is the case where the Supreme Court ruled that you have to provide an appropriate education, what later cases said a Chevy and not a Cadillac. And people use that to say, well, we're at this level, so we don't need to provide services anymore. In Rowley, they weren't asking to continue services, they were asking to add additional services on for a child who was doing very well at school. And the court ruled that, no, she's doing really well, you don't have to do more. But there's nothing in that ruling that says the child is doing well, you can do less. But people quite often misinterpret those rulings. So I don't really blame Amy Rowley. Please don't repeat that. She's actually a professor in California these days. So I hope that answers your question. Is data. The answer to almost all questions is more data, and more data created and documented by people with appropriate initials after their name.
Thank you so much, John. It is a challenge to include so much in an hour talk, and I think it was wonderful. And thanks to all of you participants for joining us today. And we hope you will visit our website and join us and register for some of our upcoming talks.
Thank you.
Well, thanks for having me. I hope I helped some. So nuts and bolts speak. What do I do now?
Yeah, thank you all for joining us. This ends the webinar.